Beautiful. So we'll get started. What is it? We're 30 minutes into live.
We're 30 minutes into our 30-minute presentation.
Roman, thank you for being on.
Thank you for having me.
We're not only going to figure out deeds, but Facebook Lives as well. It's going to be pretty amazing.
Yeah.
So,
pro tip for everyone:
Roman,
you can't add someone to your camera unless you're on a phone, not on your computer. So
there you go, something new. As far as what I know about you, Roman, you are an awesome, amazing, actually, you're not a real estate attorney by trade, right? Trust, wills, estates, and then because your clients love you so much, they say, let me hire you for the real estate contract process.
right. So we do a lot of estate work. We help people plan their estates and then help their loved ones sell property after someone's passed. And so a lot of our real estate expertise comes through the sale and on estate sales, but we have plenty of clients who use us for purchases as well, a lot of whom use Robert. So we've had an opportunity to work together for years.
Amazing. No, I love the way that you work. I like how diligent you are. It's funny. Some people are like, no, Roman is too straight. Roman knows this. I'm like, yeah, Roman knows his stuff. Roman knows exactly what he's doing. This is why we're having this conversation.
I appreciate it.
But what I'd like to, I guess with the wealth of knowledge that you have, if we can educate people, the most important thing after buying a house, right? You purchase a property, you have a deed. The deed can be in a personal name, the deed can be in an LLC. Some people put a deed into a trust when there's no mortgage involved. What is the most important thing that you would say from what you've been seeing from your experience? If a personal name goes on a deed, if it's a primary resident, if it's a husband and wife or a parent with a child that go on a deed, what is it that you're seeing that's a misconception or something that's being done wrong or that's not being explained correctly by attorneys? What can you give as a feedback?
Yes, that's an important point. And a lot of times what I see is that when we're doing sales, we have the buyer, who we don't represent, come to the closing, and you see him there with his attorney, and the attorney asks them, it's usually husband and wife, not always, but usually, and they'll ask them, how do you want to hold title? You know, whose name should we put it in? Or do you want to be there as joint tenants or tenants in common or tenants by the entirety? And it's like the first time they ever heard that question. How are they supposed to know what that means? And what we do is we deal with the aftermath of that decision. We deal with people whose attorney maybe hasn't explained to them what the consequences are, and now they're like, whoa, I had no idea it was this way. If I had known, I would have done another way, whatever the case may be. So I think it's just important to understand that an individual name, or if you're not doing it, we can talk about an individual names, there are 3 ways to approach. And by the way, did you hear me okay? Because my phone rang. Did it cut off audio?
Your phone kind of cut off your voice.
Okay. So that's interesting. I have to,
in an individual.
Wait,
so
give me one. Yeah. Give me 1 second. I want to actually pause my phone from ringing and
do not disturb.
No, I have to actually change settings. Give me 1 second.
More technical, more learning, technical.
You know what? I'm not even sure. I wasn't expecting to be on my phone, so I didn't set my phone not to ring. Let me do one thing here. You know what? I may not be able to do it. I'll just pause when the phone rings.
Whatever. We'll pause when it rings.
So you can obviously own something in your own name individually. You could buy it in your name. You're not, it's yours. The problem is if you're married, and let's say someone is looking to make sure that if they pass away, their property automatically goes to their spouse. Well, putting it in your name doesn't help you much, because if something happens to you, how does your spouse inherit that property? So people assume it automatically passes. It's not necessarily the case. In fact, especially if you have children, it's going to have to go through a court process, and it's going to be a dragged out, event. So first thing is just think about like long term. I'm buying this house. Something happens to me. Let's say I'm in my 40s when I pass away. I want everything to go to my my spouse. I don't want necessarily just to, go through a court process. How do I do that? So consider putting your spouse there. That's number one. But then there's like...
So hold on. You're saying putting a spouse on the deed initially, right?
Mm-hmm.
Okay. So what's pretty cool about the mortgage process is that if a person's on a deed, they don't necessarily have to be on a note, or saying that they don't have to be responsible for the debt by a person being an owner of the property. So you're saying putting a spouse, okay.
Right, so if they don't have to be on the note, but let's say they just want to proactively plan, then you definitely want to add your spouse. And then there's different ways to add them, and we can talk about the 3 different ways. But you just want to at least consider that first step, because sometimes people go back and forth. Should I add them? Should I not? Do they need to be there? And there are some ramifications. Obviously, if you ever get a divorce and you used your own funds to purchase this house, your spouse will have a claim on that house, more so than if you didn't put them on. So there's obviously things to consider there. But from a purely like estate planning perspective, it makes sense to put the spouse on there. And I've seen, I'll give you an example. I had a lady whose husband passed away. I think it was in his 50s or 60s. She had, I think it was 2 properties, and married to her, and had 2 children, and he had a will. And the will left everything to his wife. So after he passed away, because the properties were just in his name, she had to hire an attorney, hire us to go through the court process of getting that will admitted to the court. Then the court had to appoint an attorney to represent her minor children, because they were under 18 at the time, to make sure that they were not improperly disinherited. Because what was happening is that instead of giving the kids their portion and her portion by law, the will superseded all that and gave it just to the wife. So the courts come along and say, wait a second here. We have this piece of paper, this will that disinherits these kids. We want to make sure it's legitimate. So that whole process, nobody contested, nobody fought, but that whole process took about a year, and obviously thousands of dollars, not only in legal fees, but court fees, court attorney fees. It's unnecessary. Had he just had her name there together as husband and wife, both properties would have passed instantly and automatically to his wife. So there's something to consider. However, again, there are, legal consequences as a result of that. Some people may not be comfortable giving their spouse, especially if, let's say, they've gone into a marriage, it's their money, they came into it, and now they're putting their spouse on it. Their spouse may have a claim, for half of that house, as opposed to if they buy it in their own name, they may have some more protection. And I'm not a divorce attorney, so I can't tell you exactly the details, but there's certainly consequences of adding a spouse. So that's the first question. You want to make sure that it automatically goes to your spouse, and even if they're not on the mortgage, like you said, you can still put them on the deed sometimes, and that'll protect them.
But it doesn't necessarily have to be a spouse, right? I don't mean to interrupt. It could be a child, it could be a sibling, it could be anybody else that you could add on.
Yeah, a business partner. You certainly can add anybody, and then if you do that, so now the question becomes, all right, well, how are you going to put them on there as joint owners? Are you going to put them as tenants in common, which means that you own 50% and they own 50%? And then what happens is, if one of you passes away, your 50% doesn't necessarily automatically go to them. You can provide that my 50% goes to my kids, and then they can provide their 50% goes to their kids, or whatever the case may be. Let's say if you have 2 siblings on a property, for example. And not only 2 siblings, sometimes husband and wife. They buy a property, it's a second marriage, they have no kids together. They want to provide that when each one of them passes, maybe the surviving spouse has the right to live there, but when that other spouse passes away, their 50% should go to their kids. And not that when they pass, everything goes to their surviving spouse, who then gives it to his kids, and then your kids are disinherited.
Understood.
Yeah.
But when you're saying that, when is this decision actually made? So if you own the property 50-50, right? 50% is owned by, let's say, the wife, and then something happens to either one of the spouses. Who makes the determination who that 50% goes to?
Right. So the decision is made essentially when you purchase the property, or at any time thereafter when you can update the deed to reflect what you would like for it to be. So you can have sometimes people who buy it in their individual name. Later on, they'll add a spouse, or sometimes you'll have people buying together, and later on they'll remove it. You may see that a lot of times in the, I guess, in the refinancing context. Somebody goes on a deed to qualify for a mortgage, or they go on a note and they go on the deed as a result, because their income is necessary to qualify. But they're not really owners. Like it's not meant for them to be the owner. They are the owners, but it's not meant for them to ultimately own it. So what happens? Someone goes on with somebody else, and then at some point, let's say the mortgage is paid off, that person is removed from the deed some later. So the decision can always be adjusted. It's not necessarily locked in. There's one exception to that, if you want to get to that. But generally, the decision is made at the time a property is purchased, so that you don't have to waste time and money redoing deeds and refiling everything.
But it could always be changed, right? For a fee or...
Almost always.
Okay. Okay, so that's tenants in common.
Yeah. So
then there is
so tenants in common can always be changed, right? Because tenants in common is I own 50% or whatever the percentage is. You can allocate percentages, and that's different than joint tenants with rights of survivorship. So joint tenants' rights of survivorship means however many owners there are, they each have an equal stake, and when one of them passes, the others remain owners, and then when another one passes, the next remaining owners. And so it's just basically the last survivor wins, essentially, and inherits the whole thing.
Interesting.
So with that, even if you have a will and you say, I give my percentage to my kids, it doesn't matter what your will says, because once you own as joint tenants with rights of survivorship, it's automatically going to pass to the surviving owners on that property. Now, if you're the last living owner, then it goes through your will.
Last living owner that was put on the deed at that particular time, right?
Yeah, so if you have, let's say, 4 owners, 4 people buy it together, and they have a joint tenants rights of survivorship. So when one passes, the other 3 owners are the remaining owners. When the 2 people pass, you got 2 owners, and when 3 people pass, the last guy that's alive, he owns 100% of that property.
Wow. Okay. Okay. So just basically, what about inheritance? Is that like a completely separate topic? Because he became owner, you have to pay some kind of a tax on it. Does he have to pay kind of inheritance tax, or is that not applicable in this case?
So if somebody's the last surviving owner and then they pass away, you mean?
Yeah.
So essentially, it depends. If the property was just in his name, assuming he had a will, that will has to go through that court process.
Okay.
Is there a tax? There's estate tax to the extent that the gross estate, at least in New York, exceeded $6 million approximately.
Okay. Okay.
Otherwise, the first $6 million you leave to your next of kin is tax-free, and anything you leave to your spouse, assuming you're married and they're U.S. citizens, is unlimited as well. So you can leave unlimited amounts to a spouse, up to $6 million to anyone other than a spouse in New York. Now you're in Florida, so if anyone's watching in Florida, there's no estate tax on a state level in Florida. There's a federal estate tax across the country, which currently is, let's say, approximately $12 million. I don't hear you.
It just makes it a little more complicated. Let's say that 3 people go on a deed.
Yeah.
One person lives in the state of New York, one person that lives in the state of New Jersey, and let's say a 3rd person lives in Florida. The last survivor who's on the deed, it goes based on the state that he's living in at that time?
So the last survivor, right, when he passes away, his estate gets taxed based on the state in which he lived.
Oh, it's freaking amazing. Why doesn't everybody just move to Florida in that case, towards the end of their...
No, but here's the thing. A portion of that is still includable in the people that passed away. So a third, let's say there's 3 owners, the first guy passed away, his third is included in his estate.
His third is included, okay.
In his estate,
so
in which he lived.
Got it. So there would still have to be some kind of a payment, but just from the third.
Potentially, if the estate exceeds a certain limit, right? It's included in his estate.
Okay. Okay, makes sense. What's the next option?
So the most common option, frankly, I would say, like maybe, I don't know, 70, 80% of the time that we see people purchasing a property, it's a primary residence. And let's say 70, 80% of that time, you have husband and wife purchasing it together. So the question becomes then, well, how do you add your spouse? Because there's 3 ways to do that. You can put them as tenants in common. So you each own 50%. So you each can control your 50% interest. But then again, when one of you passes, that 50% has to go through a court process, through the will. So that's one approach. The other approach is you do it as joint tenants with rights of survivorship, so that if one spouse passes, it automatically goes to the surviving spouse. No court process is necessary. And then the third one, and the more common one, and the ones you probably see all the time, is when people put their names, but they put husband and wife at the end of it. Or sometimes they don't even put anything, but they are married, they're husband and wife, and they just list their names. So if you do it that way, what you're doing essentially is you're accomplishing the avoiding of probate, so it automatically passes, just like the joint tenancy rights of survivorship, just like that second option. But in addition, what you're doing is you're creating what's called tenants by the entirety, which only spouses can create. And so what that gives you is the protection that if anyone ever sues you or your spouse, and essentially, let's say they have a claim against you, they have a judgment against you, you owe them money, and now they put a judgment on you. That judgment does not attach to your property as long as your spouse was not also responsible for that debt. So I had an example where a gardener messed up, and my dad paid him, and he didn't do the work. And my dad sued him, and he won. This was many years ago. So he got a judgment against him. Right. So he goes, he tries to collect, and he can't. Why? Because the guy owns a property with his wife. So my dad has nothing to do. He just has a judgment against the guy. He can't enforce that judgment against the house because the guy's only asset that we found was a house, and he owned it with his wife. And so basically can't do anything with that house unless and until either the wife passes away and he's left as the only owner. Now it's against him, that's fine. Or if they sell the house, and as you know, on the title report, you get a judgment pops up, and now you got to clear the judgment. So he happened to, this gardener ended up selling his house, and eventually my dad got his judgment.
Oh, nice. So there was no statute of limitations or something like that?
There's a statute. I believe it's 10 years for a judgment, and you can perfect it and extend it for another 10, I believe. I'm not 100%. I don't do collections, but the idea is that it gave him protection against his creditors. That house was protected. All right? So that's what tenants by the entirety gives you. By putting it in your name with your spouse as husband and wife, as tenants by the entirety, you're protecting your house from having creditors placed on it and having it foreclosed. Unless, again, you sell or your spouse passes first. Or you get a divorce. I guess that's the other option.
Or you get a, okay. So now, let's say the fourth option, right? You put a property into a name of an LLC. Which a lot of people are asking about right now is, how do I put the property into an LLC? It's more protection. I can't be sued, or they're going to sue the LLC. And I'm seeing it's more and more common for investment properties to be put into an LLC because, number one, mortgage companies allow it. Number two, I think everybody just suggests that that's an option. What do you say to a title in LLC?
I think an LLC is a good idea as long as people just understand that it gives you one-way protection. An LLC means I own shares in a company. I own a business, right? So it's my asset. I own it. The only thing is that if something happens with regards to that business, you can't touch my personal property as a result of it. But everything in that business is still open season. So I'll give you an example. You walk into a pizza shop, you slip, you fall, you get hurt, you sue. Let's say their insurance is not sufficient, doesn't cover your damages. So now you're like, all right, well, I'm going to sue the business. I'm going to sue the restaurant, whatever. You go ahead and you sue them, you get a judgment against them. Can you now go after, Tony the pizza guy because that's his restaurant? Or do you only have the right to go after his business? So if structured properly, an LLC or corporation, the only assets you can collect are those that are owned by the business. And you can't go after the restaurant owner's house or bank accounts or any other of his assets. However, if you have a property in your own name and somebody slips and falls, or you have a dispute with a contractor, or there's a fire, you damage a neighbor's property, and there's no insurance coverage or it's insufficient, then if it's in your own name, they can not only take the property that you own, they can also get a deficiency judgment and they can go after your additional assets. However, if you have a personal judgment, you're driving in a car, you get into an accident, your insurance disclaims coverage or whatever the case may be, or you have some other personal debt, and now somebody sues you personally. Well, if they're suing you personally, what happens essentially is that all of your assets are open to them. And you own an LLC, it's like you owning shares in a company or a business. So what's the difference? Just like you have cash in a bank account, you have an LLC, that's an asset. They can put a charging order against your LLC. So the point is, the LLC doesn't mean that your creditors can't access your LLC. It means anything related to your business, especially if you have an operation that's ongoing and people are coming in and there's contracts, and it's not just like a one-family house, but something more, say, more nuanced, more intensive, more business intensive. You want to make sure that any claims will be limited to just the assets in the business. And what some people do is they'll take a property that's leveraged. They'll take a property that has, let's say, $1 million property, and it's got maybe only 200,000 in equity, and they'll take that property, put it into an LLC. They know their maximum exposure there is $200,000, unless they, I guess, personally co-sign on the LLC loan. But basically, they know that their house, their other investment properties, their bank accounts, their other stocks, bonds, they're going to be protected. And the most they'll ever lose in that business is whatever's in that LLC.
Got it. So something that I always suggest, and I kind of reiterate this over and over, when a person says, I want to put it into an LLC, I say, start a brand new LLC specific to this property.
Mm-hmm.
Don't have an LLC that owns any other properties, any other businesses. You want to have a single asset LLC for every single property.
Mm-hmm.
Is that correct? Is that the right thing to do?
It makes perfect sense, because the whole point of the LLC is to limit each property from liability of other properties, or to limit the liability of your assets to the one property. So if you have one LLC and you put a bunch of properties in there, so let's say there's an issue with one property, it's going to be able to be assessed on the other property as well. Now you're exposing multiple properties, as opposed to what you're saying is have separate LLCs. The worst that'll happen is, again, one will be at risk, but at least the other properties are completely protected. So your advice is exactly right. And especially in states like Florida, where setting up LLCs are not as expensive, is not as expensive as in New York. Because in New York, you have to publish in 2 newspapers for 6 weeks. There's a filing fee, so it ends up being quite expensive. But in the long run, I think it gives protection that's worthwhile.
In the long run, okay. And going back to that LLC topic and the pizza owner, I don't know why we're talking about the pizza owner, but if the pizza owner gets sued and he has another property in a completely separate LLC, does that property get protected from his lawsuit?
If he gets sued from the business,
if his pizza shop gets sued from that slip and fall, but he has 3 other properties in a complete separate LLC, is he protected on those 3 properties, or there's still a way to go after it?
Yeah, if the pizza shop is in an LLC or a business, then they can't go after the other properties.
Beautiful. So then every property should be in an LLC. Every
business, every restaurant should be in a corporation or LLC. It's a small thing. You just started. You want to have a simpler approach to things. Fine, do a sole proprietorship. But as soon as you scale up a little bit, certainly if you have employees, you definitely want to make sure you protect assets, because you have, outside your business, you have all these other things you may be running, operating, owning. Those should not be exposed because something goes wrong in your business, and that's what the LLC helps you protect.
Okay. On another note, now that this helps for mortgage purposes, when do you open up a trust? Or when do you open up a holding company for the trusts?
So with the mortgage, depending on the bank, some banks allow revocable trusts to be owners and borrowers. Some give a harder time. Many don't allow irrevocable trusts. I'm going to stick to revocable trust at this point, because usually when people are buying their property, they're not necessarily looking to lose control over them like an irrevocable trust does. They're looking just to make sure that if something were to happen to them, they're going to be protected. So the law on this is that if you have a property you own and you have a mortgage on it, it's a residential property of 5 units or less, you can put it into a revocable trust in which you're still the beneficiary and still the one in charge. And the bank is by law precluded from foreclosing on your loan. So they can't say you violated the terms of the mortgage, we're going to call it. So if your bank doesn't allow you to do it up front, you can always do it thereafter. So say you close, you wait a few weeks, you set up a trust, you can transfer that property into the trust. Setting it up into an LLC, if you have a mortgage, is more problematic, because then you'll technically be triggering their due on sale clause, which basically says that the bank says, I'm giving you the loan, not a company. You can't transfer it to the company without our permission, and if you do, we can cancel your mortgage. So again, do they find out about it? It's a different story, but at the end of the day, you'll be in violation of one of their covenants, and they may
that's when they can call a note.
Right. So again, you'll be careful with that. But if there's no mortgage on that property, one approach may be to set this up. So take that property, assuming it's an investment property, not a primary residence. Take that investment property, put it inside of an LLC, so you get protection. And then you take that LLC and you assign the interest over to the trust. So that way, number one, you're protecting against creditors of the business. But number two, you're also providing succession. You're saying if something happens to me, I got this 6-unit apartment building and I have tenants that need to be managed on a day-to-day basis. I can't wait 6 months or a year for the court to let my wife or my child become the one in charge of this estate. I'd rather get them immediate access, and that's what the trust does. The trust skips that court process, gives them immediate access, because essentially you're transferring ownership while you're alive and providing for a successor trustee to step in automatically. So it's a continuity based on that trust agreement, as opposed to saying, oh, okay, the owner passed away, now let the court decide who's in charge, and that process takes, like I said, takes a while.
That's awesome. So why not do it on a primary residence as well? You said
So,
that to do it on an investment.
Yeah, so I would do a trust for a primary residence, certainly. An LLC stands for limited liability company. It's meant for business entities. You don't have limited liability protection if the asset you put in is a personal asset. So
Understood.
it's
Okay.
not going to provide you, if somebody slips and falls on your property, it's not going to provide you protection, essentially. You have insurance for that. And again, it's not much of an issue, but it's meant for businesses, and so therefore, you know, putting a house into an LLC won't give you protection, at least not creditor protection.
Understood. Okay, so anything that has to do with an investment, you're always going to suggest to put it into an LLC and then transfer it over to a revocable trust.
I wouldn't always suggest it, because look, at the end of the day, how many times do you have people who have lawsuits that aren't covered by insurance, you know, fire, flood, whatever the case may be? I personally haven't heard of a situation where someone had a liability with a property that exceeded their insurance limits, and now their personal assets are at risk. Now, again, I'm not an asset protection planning expert. I do estate planning. It's a different ballgame. But at the end of the day, the risk of having something like that occur is so small that the benefit of an LLC, it's there, but it's not a high likelihood. So I can tell you that I tell all my clients, oh, you must already invest in property into an LLC. Sometimes the risk just isn't there. It's not a high-risk property. They have sufficient insurance. They have umbrella coverage. They have good policies. And so they may get protection that way. So at the end of the day, the LLC may not be worthwhile for them, especially if they're not doing a long-term hold. They're buying it, you know, fixing it up, or maybe holding it for a couple of years. You know, to set up the LLC, to transfer it, to pay those extra fees may not be worth it for them. So every situation is different, but it's definitely something important to consider to see if it makes sense for you.
Can multiple properties be put into the same revocable trust?
Yeah. Ultimately, you have one trust agreement, which is a contract specifying what happens to your assets if something were to happen to you. So you can specify multiple assets generally. You can say, like, everything I own goes as follows. Or you can have specific bequests of property. With these trusts, you can always amend your beneficiaries. You can amend who gets, the property when you pass. So, yeah, we usually have one trust for an individual acting on behalf of multiple properties and multiple LLCs sometimes.
Interesting. Do you open up LLC? Do you open up trust? Is that what somebody that's watching this video can come to and say, Roman, help me open up a trust or an LLC?
Sure. Yeah, we've opened up hundreds of trusts and hundreds of LLCs. That's what we do. So happy to speak with anyone who has any questions on that.
That's awesome. I'll tell you why I'm asking if you could open it. In New York, somebody had to open up an LLC. He saw the fees and he's like, oh, I might as well go on one of these websites and open it up on my own. It'll save me some money.
Mm-hmm.
I'm like, dude, that's never ever a good suggestion, but if you want to save some money. The funny thing is that by the time he corrected all the mistakes and everything that he made with opening up his own LLC, he ended up spending about $600 more compared to what his attorney quoted him to open up the LLC. So I'm like, if you're asking for something good, always go to a professional. Don't just depend like the same exact thing for a person going to get a mortgage on an online company. You have to deal with a professional. You have to deal with somebody that knows what they're talking about. And don't try to save on costs, because when saving on costs, it will always backfire and you'll end up spending more. What is it?
I agree. I think it's important to get professional advice. I would say also with setting up LLCs, most of the fee that attorneys charge, most of those fees are just basically paid to the newspapers and to the state. So there's not like a huge profit margin on LLCs. We don't do them to generate, you know, revenue. We do them to build a relationship, to continue working with the client for, you know, future deals. But I think it makes sense to speak to someone, because aside from setting up the LLC, first of all, you want to make sure you're publishing it correctly. Yeah, make sure you're taking care of the the state requirements. You have a valid LLC if something ever needs to be enforced on it. So that's a mistake. And by the way, people set up their own LLCs. If they do it online, you have to find 2 newspapers. Like, we have connections with newspapers that give us very good rates. So it may end up actually being cheaper to use an attorney because we just have those connections. And then at the same time, we set up the operating agreement. We tell you what you can and can't do with the LLC. We get you the tax ID number. So it's a small investment. You're paying maybe a few $100s more for that legal advice, but I think in the long run, it's a big benefit to the client.
Absolutely. Listen, you go through this on a daily basis. It's better to talk to, it's always better to talk to a person that knows as opposed to doing it on a computer. So thank you. If you could just share your phone number as to if somebody wants to open up an LLC or if somebody has questions. And speaking about questions, this, I know that we had some technical difficulties in the beginning, but I'm so happy to have you on because I know that your advice is worth a lot of money. I know that you charge a hefty fee because of your knowledge and because of what you do. If for somebody who's watching this and they mention it, is there any kind of a discount or some kind of a consultation that you'll provide ahead of time so that it could be beneficial? And I want people to use you because I know how that mindset, that wealth of knowledge that you have in this industry, and that's why I said I'm so comfortable when people come to use you. What can you offer to these people?
Sure. So any clients you have, anyone who's interested, you can always have them give me a call. My number is 347-766-2685, or easier to remember, 347 Roman 85. And
that's so cool. I'm going to post it in. Hold on, 347. That's a pretty cool number. Roman 85.
Yeah, and I'm born in 85, so easier to remember.
Nice.
Yeah.
Okay, good. You
So
just gave everybody your age. I try to make you sound a little bit older and knowledgeable, but okay, you just gave it up.
Sorry. But
as if you look older.
But I'll be happy to speak with anyone who has any particular questions. We have a free phone consultation. We usually have an in-office consultation fee, which I'll waive for any clients who want to come in. Any of your clients want to come in person. And so, yeah, anything I can be of help with. I also just want to point out one consideration. When I mentioned before, I said, for the most part, you can change your mind about how you structure these deeds. I want to just add one caveat in there so people are aware of it before they pull any triggers on these things. I once was at a hospital meeting with someone for their estate plan, and I was running out, and a nurse comes to me and says, "Hey, I want to transfer my house to my husband." So I said, I'm sorry, I want to transfer my house from my husband to my kids. I said, all right, fine. So I kind of looked up her deed online and looked on Acris, and I saw that she owned it together as husband and wife, like we spoke about, right? So that means that you have creditor protection and passes automatically. But the one downside with that, if you own something as husband and wife or tenants by the entirety, the one downside is that if you want to give your 50% to someone other than your spouse, let's say her case, she's like, look, he's a nice guy, I like him and everything else, but I want to leave it to my kids. I don't really want to give him my half. And it was like very heartbreaking after I did a little research and I looked up the deed that I had to tell her, I'm sorry, unfortunately, you can't just give away your 50% to your kids. You can't set up a trust and put that house into the trust, or even do a will if he's alive and he doesn't consent. And her husband doesn't consent. So in that, wouldn't consent, or she didn't want to speak to them. I don't remember the exact details. But the downside is that once you do tenants by the entirety, you have to get the other spouse's consent before you decide what you do with your 50%. Otherwise, you risk that you pass first and it all goes to them and they can do whatever they want. Now, if they pass first, it all goes to you, of course. You're okay with that. But if you want to make sure you want to lock in that 50%, you don't want to do tenants by the entirety unless you know you're going to get your spouse's consent to deal with it after the fact. So that's just one thing that it's popped up numerous times in my practice, and people were shocked, like, why can't I do with my 50% what I want without having to get my spouse's consent? Because that's the downside of having all that protection, is that you need the other person's consent.
So if I could give one piece of advice on any couple that's buying a property is don't set up the deed as a husband and wife initially, right?
No, I'm not saying that. I'm saying for the most part, that is how people set it up, and that's how people should set it up. But just know the ramifications of what you're doing. Don't come to the closing, because I see it handwritten in a lot of times. They come to the closing, And then, how do you want it to be held? Tenants in common, joint tenants' rights of survivorship, tenants by the entirety. You kind of handwrite it in after the fact. Like that should not be the time you have that conversation. If you're going through the purchase process now, maybe speak to either the attorney you're working with, if they're familiar with these concepts, or an estate planning attorney, and just try to understand what the different ways of owning that property are, and make the decision that's right for you. Most people will make husband and wife decisions. That's how you will own your property, because you want it to go to your spouse, because you want that creditor protection. But it may not be for everyone, especially if it's a second marriage, or if there are creditor issues on the other spouse's name. You just want to think through that ownership process.
So this all can be changed all prior to the closing, but you're saying have the conversation up front when you're doing the contract signings.
Right. So I would say between the time you sign that contract, maybe even before you sign that contract, because you want to know who's going on that deal in the first place. So I would say at the stage in which you're making that offer, getting that mortgage, going to someone like you to obviously get the best rates and quality service. So make sure that in that process, you're saying, okay, well, is it going to be one of us or both of us? Is it going to be, something that we want to have our individual control over, our 50%? Or do we trust one another to leave the entirety to the second spouse, not worrying about what they will do with it if something happens to us?
Understood. Okay, cool. If we could answer a question, we have one of our esteemed colleagues, the insurance man, Mr. Koba. He asked a question: when does a young couple start with the whole estate process? When do you suggest for all that to begin?
I would say no later than around the time of the birth of your first child. Because before then, if you don't have anything set up, your spouse inherits everything automatically. They have the right to make your medical decisions and whatnot. But once you have that child, that child becomes one of your heirs and ultimately is entitled to a portion of your estate. So you just want to make sure that they're protected, that your spouse is protected, and that if something happens to the both of you, you've picked people to be in charge of, number one, the physical custody of the child, their guardian, who they will live with. And number two, who's going to be in charge of handling all the financial affairs. You've left life insurance, you've left the house, you've left other investments. Well, who's going to take care of that for the child? Are they going to get it dropped in their lap when they turn 18, which is what happens if you don't have an estate plan? Or will it be held for their benefit, invested, managed, given to them as they need it while they grow, and then be given them in stages as they turn 21, 25, and 30, for example? So I think at the time, maybe right before that child is born, you should have your estate plan set up.
Understood. So if you're already on kid number 2, then you're definitely late in the game, but they should contact you as soon as possible.
I would say, yeah, as soon as you're thinking about having kids, it's probably a good time to set up a will.
You mentioned about the spouse thing. If I could just go back on that real quick. There's a lot of people that I come across who are married, but not by City Hall. They don't have a U.S. Marriage certificate or whatever it is, but they do have by religion, a Jewish ketubah or anything similar to that. Does that count in court as far as that's your spouse, that's who the property will go to automatically, or is there some...
Yeah, that's funny you asked that. I was going to mention it. I'm like, nah, I should go.
It does happen a lot. I'm sure you see it as well.
Oh, yeah. I mean, yeah, there are court opinions on this. There's a Muslim court case, I think in New Jersey. There's Orthodox Jewish cases as well in New York. But essentially, in New York, you don't need to go to City Hall, get a license, and be married civilly in order to be entitled to spousal rights. And so just because you think that, we're not really married and we never, got the official certificates, if something happens, the spouse that survives still has marital rights, or even in a divorce situation. As long as you had a ceremony and witnesses, if it's something official, if you live together as domestic partners, that's not marriage. But if you've had essentially what looks like a marriage, the wedding hall and the whole thing, you're basically married legally as well, even though you don't have a certificate, with all the rights that come with it. I'll put a caveat out there. I'm not a matrimonial attorney. I'm not a divorce attorney. There are many nuances there. Don't rely on this advice. None of this advice should be used as specific advice.
It's all BS. We're just joking.
Yeah, no, but basically, you don't think just because you didn't go down that your spouse does not now have rights. And by the way, I've had people who have gotten married religiously, and now they want to give a get. They have to not only give a get, they have to get a divorce decree from the courts if they want to be protected from that spouse coming after any other assets that they have.
That's interesting. That's a complete separate other conversation.
Yeah.
Somebody, you know why I feel that this is such an important conversation is somebody once asked me, hey, do you have a trust set up? This was years ago. And I said, no, what do I need a trust for? He says, do you own a property? Do you have kids? Do you have any kind of assets? Irrelevant of what they are, irrelevant of the amount. I said, yes. He said, every time you go for a drive, every time you fly in an airplane, you should be thinking about your kids, your family, and those assets. Because if something happens to you and you don't have a trust set up or a will set up or your deed was done incorrectly, then you're leaving it all up to chance. You're leaving it up to court to make a decision on what's going to happen with your assets, what's going to go. Because again, it wasn't set up properly by the right attorney or by getting the right information or getting the right counsel advice, right? So I think that if you have any type of assets, anything, you should revisit and sit down with you, and whether it's a will, whether review the trust, whether it's whatever it is, but just make sure that it's all set up. And then how often do people have to come back to update their will or update their documents? What do you suggest on that?
Well, first of all, you made a great point. If you don't have things set up, if things aren't jointly held with your spouse, if things don't have beneficiaries listed, then it's going to be a process to go and get access to all those assets. So what I tell people is just like what you said, make sure you know exactly what you own and how you own it. And make sure that for every asset you have, you know exactly how that asset is going to pass if you pass away. Now, a lot of times people will have, let's say you're married, so you have properties owned together with your spouse, you have bank accounts that are joint, you have beneficiaries listed on all your assets. So then in that case, if something were to happen to you, even without a will or a trust, that automatically just goes to your spouse. It's not a big deal. If you have an asset that didn't have a beneficiary that wasn't joined, then essentially it has to go through a court process. If you don't have a will and you don't specify who gets it, at least in New York, the spouse gets the first $50,000 in assets, and then the rest is split between the spouse who gets half and the children who get the other half. So it's not like the state takes it. It's not like there are going to be more taxes. It's just a bit of a more complicated process to go through just to be able to access those items. So it makes sense to just plan one by one, make sure all assets are covered. That's why our questionnaire is like 9 pages long, and it asks about probably 40 different types of asset categories, because we want to make sure you didn't miss something, whether that be your personal property or whether that be an LLC interest that you have with somebody in a different state. Everything should be accounted for. And as far as reviewing things, I mean, anytime you make a major purchase or let's say a major sale, you want to make sure that your plan is properly tailored to take that into consideration so that your assets are all accounted for. If you obviously have any children that you want to include, or actually if you had any more kids, you want to update your trust. Sometimes people will shift around how much they're leaving their kids or how much they're leaving to their kids. So if your wishes change, obviously, I'll revisit that issue. And then ultimately, if people get older, so let's say in your 40s, you're looking in your 30s, 40s, 50s, maybe you're looking in the accumulation stage. You're working, you're making money, you're investing. And then when you're maybe in your 60s and 70s, you're looking more in the protection stage. So the plan you had when you're 30 shouldn't be the plan that you have when you're 70. And maybe you're looking to now protect assets for things like long-term care. And maybe you're comfortable giving up some control in return for asset protection, Medicaid planning, things like that. So I would say that as life stages change, one should also revisit it. But in general, I always tell clients, call me if you have any questions whatsoever. But at a minimum, let's touch base every 5 years or so, just so we can talk about what changed, what updates may need to happen. And for the most part, 95% of the time, nothing needs to be changed. But just so you have that peace of mind, I think it's important to take 5 years or so.
Yeah, so Roman, if we can get this video out, I know that, again, we went off of schedule, but I think it's very valuable information, and maybe we'll do another video later on now that we're professionals at this, how to answer other questions. I think people are doing an injustice when owning a house and not having their estate set up or their wills or whatever it is, just leaving it up to chance. You never know what's going to happen tomorrow, but it's an asset. You put a big down payment, you built a lot of equity into the property, you have a family. Get in touch with Roman, get in touch with you, set up an appointment. Whatever needs to be done to protect that asset, it's super, super important, because we see people, it's funny, we hear it most when it's with celebrities, like a celebrity passed away, he had a huge estate, and he didn't have a will or a trust, and now the court has to decide where what's going. Why do we have to leave it up to chance, right? If we can get it set up. The news
Right.
is there's two things that are for certain to people that are listening. It's paying taxes and death. We're not going to avoid death because sometimes people are like, I'm not dying yet. Why do I need to set this up? It's going to happen eventually. You might as well get started at some point. Taxes are also, it's like those are the two definite things in life. So the sooner you start, the less of a chance you leave for later on being a problem. And like I said, get in touch with Roman and hopefully you can get this set up properly. If something needs to be removed, if a name needs to be added on, transferred to an LLC, you'll help with that as well. But I'm very happy that you gave the information, and hopefully people will listen and get started on this. So
I appreciate it. I
again,
appreciate the
phone
opportunity
number
to come on. And
347 Roman 85, and that in
that's
numbers.
it.
In numbers, that's say it again.
No. I think we have a little bit of a lag. I was just saying thank you for for having me on. I appreciate the opportunity to have worked with you for all these years. You're a professional at what you do. I think your clients are well served because they can come to you not just for great rates and great service, but also for advice and counsel. And you look beyond the immediate deal. You look beyond that. You look to the holistic approach. What does the client need? What's in their best interest? And so I think that your clients are well served with working with you. And if I can be of any help to them, I'm always available.
Appreciate it. Thank you very much, Roman. And we'll be in touch soon. So guys, again, 347 Roman 85, and just share your email real quick. We'll put that in the group chat as well.
I don't know if I could do that here, but it's roman@aminovlaw.com.
So original. aminovlaw.com, right? .com. All right, so people will contact you there. Aminov Roman. Why did I write Roman? Okay, I just want to make sure that I'm writing the right email for people to share. There you go. Okay. Roman, thank you very much.
Thank you, Robert. Always a pleasure.
And we'll talk soon.
You as well.
Take care, guys.
Bye-bye.